thank you. Can everybody hear me okay? Yes, okay. Well, welcome to our second panel of this fabulous day. This panel will focus on the case West Virginia versus EPA. It'll focus on navigating climate action and administrative authority in the wake of the major questions doctrine. So we are very fortunate to have today two scholars with expertise to help us understand the significance of this very important case. Greg Dotson is the University of Oregon School of Law, Environmental and Natural Resources Law professor. After a very long career on the Hill before joining the faculty, he has had service since February 2001 as the Democratic Chief Counsel for the U.S. Senate Committee on Environment and Public Works. And in this role, importantly, he used his expertise to help pass the 2021 infrastructure bill and the recently enacted historic climate bill that we'll be talking about. Professor Dotson holds an undergraduate degree from Virginia Tech and a JD from the University of Oregon School of Law. And Professor LawLisa Heinzerling is the Justice William J. Brennan Jr. Professor of Law at Georgetown University Law Center. Her primary specialties are in environmental law and administrative law. Her many publications include a leading casebook with Professor Zygmunt Platter and others on environmental law. The US Supreme Court cited one of her law review articles entitled "A Perfect Storm, Mercury and the Bush Administration," in the opinion that we will be discussing today. In her time at Georgetown, she has continued to litigate important environmental law cases and served as lead author of winning briefs in the Massachusetts versus EPA case. Professor Heinzerling holds an AB from Princeton and a JD from University of Chicago. So I welcome our very distinguished panelists. And today we're going to talk about the case West Virginia versus EPA. Many of you know already that is a major climate change case. And climate change is obviously at the forefront of the news now and will continue to be so. In August, President Biden signed the Inflation Reduction Act into law. That law contains the most significant climate change provisions ever passed by Congress. And according to numerous energy modelers, this law will put the US on track to reduce the nation's greenhouse gas emissions 40% below 2005 levels by 2030. But as I always tell people, this is all a matter of carbon math. The science informs us that we have to, in order to avoid the worst impacts of climate change, we have to reduce emissions even more. And in fact, President Biden has pledged a 50% reduction by 2030. So there's a 10% gap. And for the president to achieve this goal, that will put the focus directly on what can be achieved through the Clean Air Act regulation. West Virginia versus EPA affects what will be possible under that act. And its ramifications are not limited by any means to the Clean Air Act or the environment. Wherever agencies are asked to make regulatory decisions, West Virginia versus EPA could have a profound impact on things like immigration, consumer protection, auto safety, drug safety, public health, and the list goes on. So with that, let's jump into the conversation. Greg, I'd like to start with you. What happened in West Virginia versus EPA?
Well, thank you, Professor Wood. It's a pleasure to be with all of you, with Professor Heinzerling. So West Virginia versus EPA is the fourth time the Supreme Court has weighed in on the issue of climate change and the Clean Air Act. And the current makeup of the court really takes the occasion to announce a decidedly skeptical approach that the court will now be using in regard to regulatory actions that have political and economic significance. The case arises from regulations known as the Clean Power Plan that EPA promulgated in 2015 under Section 111D of the Clean Air Act. 111D only applies to existing sources of air pollution. 111B, also established in that same time period, applies to new power plants and greenhouse gas emissions. That those regulations remain in effect today. So we're just talking about 111D and regulations for existing power plants. EPA had sought to establish a flexible approach that would apply sector-wide and say, we want to achieve emissions reductions in a way that's as efficient as possible. So utilities, electric utilities could use less coal, they could use more natural gas, more renewable resources like wind and solar, and there was even pathways to provide reductions through energy efficiency by reducing the amount of electricity that would need to be used. Unfortunately, that rule never went into effect. It would have required a 32% reduction by 2030. Never went into effect. The rule was opposed by fossil fuel suppliers and a number of elected officials. In January of 2016, the Court of Appeals for the DC Circuit denied a request for a stay and set up a briefing schedule. But then in February of 2016, the Supreme Court, without being briefed on the matter, issued a stay on the regulations and said that stay would remain in effect until all legal challenges had been heard. We then entered the period of the Trump administration, and in 2019, the EPA rescinded the Clean Power Plan, replaced it with a rule that was much more narrowly interpreted, the authorities of the Clean Air Act, saying that really the only permissible reading of Section 111 was that it authorized pollution controls to be imposed at the facility. And so therefore a policy that allowed this flexibility that could apply sector-wide was simply not allowed under the Act. That rule in turn was challenged by various states, environmental groups, and other stakeholders. And in January of 2021, the DC Circuit vacated that 2019 rule, and they rejected that narrow reading of Section 111D. So that really brings us to West Virginia versus EPA, in which the Supreme Court decided they would take this case up. Interestingly, in the wake of the DC Circuit decision, there was no rule in effect. The DC Circuit had vacated the 2019 rule, but it had not reinstated the original Clean Power Plan. And in fact, the power sector, due to economic forces and state regulation, had already reduced its emissions below the targets that for 2030. So in many ways, we had already accomplished a goal that exceeded the 2015 rule. Still, West Virginia and fossil fuel providers argued to the court that they were harmed by the mere existence of this rule, of the decision in the DC Circuit, and that it could spring back into effect, and therefore review was warranted. And the Supreme Court was convinced by that. They granted cert and reviewed it. Their decision came out in June 30th of 2022. They decided that EPA had exceeded its authority under Section 111D of the Clean Air Act, and that the Act did not provide for generation shifting. So that is, the Act could not set up incentives and decision-making structure and rules that would have you switch from more polluting electricity generation to less polluting electricity generation. And I think, there's notable things about this. This could have been a very narrow decision, simply perhaps applying Chevron, interpreting the words that Congress had passed in 1970 when this section was originally enacted. But the court did not do that. They actually do not mention Chevron at all. So the court immediately decided to apply its own interpretation. And it debuted, I think, for the first time using this phrase in the Supreme Court, the major questions doctrine. And this major questions doctrine essentially states that the court is going to require an agency to really have clear congressional authorization when it tries to do regulations of consequence, when those regulations have economic and political significance. And so This case, while being somewhat narrow, EPA does retain authority under Section 111D to regulate greenhouse gas emissions from existing power plants. But the court has said not like that, and hasn't provided a lot of guidance about what would be an acceptable approach. As a practical matter, simple technology controls that would, that you could use for mercury or particulate matter or nitrogen dioxide or other pollutants, or nitrogen oxides, simply won't work on carbon dioxide. It's not the same kind of challenge. So it does raise significant questions, and I think it should show us that relying on our landmark environmental laws to address climate change could continue to provide challenges to the Supreme Court. And I think that this doctrine is going to apply to really any regulation that any agency uses that could have significance and be something that is not explicitly detailed in statute. So maybe I'll leave it at that.
Well, thank you. That was a terrific explanation of how this affects the Clean Air Act regulation. Lisa, do you have any thoughts on how this does affect other areas of regulation?
Yeah, I do. I have quite a few thoughts on that. I do think this is a huge opinion, as Greg was suggesting, insofar as it requires Congress to speak really clearly enough for the conservative justices on the Supreme Court to be able to hear it. It needs to speak really clearly if they're going to hand over what the Supreme Court considers an important policy decision to an agency. The thing is, that's the way Congress handles policy choices. It states the broad outlines, gives parameters, creates the agency, funds the agency, oversees the agency, and then sets them in motion. So you rarely, even the Inflation Reduction Act we just talked about, that has a lot of obligations that agencies are going to have to take up, and they're going to have to make that statute a reality. And then a reason I say this is that basically the Supreme Court is saying whenever that relationship between Congress and the agency becomes one where the Congress is handing the implementation job to an agency, then it can't do that with respect to really important and politically and economically significant decisions without being really clear. But being really clear is really hard. And a lot of times there's compromise is possible because there's a little bit of play in the joints in the language. Sometimes it's not even, and I'll say this, I don't know another word to use, clear, whether the statute is clear. We often see statutory cases come up to the Supreme Court. I'm sure you all have seen this in your lives and practices, where there will be a circuit split on whether a statute is clear or ambiguous, all the way up to the Supreme Court, and the Supreme Court may split 5-4. In that situation, it's really hard to blame Congress for not having been clear. And that's not even the kind of clarity the Supreme Court is now requiring. So that's just all by way of backdrops. Congress passes a lot of implementation choices to agencies. In doing so, it needs to be clear going forward. And by the way, it needs to have almost foreseen this kind of ruling in the past, because this is going to apply to past choices that Congress has made. So really, really important, in my view, highly problematic ruling. We almost every day, if you read the newspapers on administrative issues, which I'm just hoping you do, because they're so interesting, that if you read them, you see almost every day a new challenge to something that the Biden administration is doing. And the challenge is based squarely on the major questions idea. So this will run the gamut. As soon as the student debt relief program was announced, people said it's a major question. The Securities and Exchange Commission wants to require disclosures of climate emissions. Major question. Immigration, major question. I don't know if a really capable lawyer could not actually make a plausible argument that a question was major, especially when what we're talking about often are nationwide rules. They're often consequential. They're meant to be consequential. So I think the ramifications, if I can answer your question, are very large. I think they cut across subject matter areas, and they cut particularly deeply, unfortunately, into areas where Congress has given the agencies a lot of room to maneuver because the facts are uncertain and changing. And so the science of air pollution, for example, water pollution, toxics, and so forth, changes. And Congress sets the agency in motion so that it can respond to emerging problems, new problems, unknown problems at the time the statute was passed. And those kinds of structures are particularly vulnerable, I think, because the court is also looking sometimes very skeptically, and was in this case, very skeptically at an agency that applies an old statute to a new problem. So for example, in a couple of cases in the last year that came up, or just about the last year that came up prior to this West Virginia case, the court struck down COVID-related regulatory measures and did so on the basis that basically, and this it's just about this ridiculous, just about on the basis that they didn't talk about the COVID pandemic, right? The statutes talked about, one of them written in 1917, I think, talked about pandemics. That's what they were worried about, but they didn't speak precisely. And so I guess the message is, in a number of different domains, this major questions idea could be quite destructive.
So Lisa, staying with you, and then I want to turn to Greg as to the relationship between the courts and the legislature in a moment, but staying with you, you've studied the court for many years. How did we get to this point?
Yeah, it's really interesting. I think two different kind of trails converged. So one was the court started about 20 years ago, 25 years ago, started unoccasionally as a kind of almost an aside, as a kind of additional reason to reject an agency's interpretation of a statute. They would say, and this is a really important question. We don't expect Congress to be subtle about these things. That's not what we expect. And so they started to drop that idea into a number of cases. And then it became more and more forceful, where it wasn't just like this another reason either not to think the statute was very clear, or clear in another direction, or to deny deference to the agency's interpretation, but actually to begin sounding like it was giving drafting instructions to Congress, right? And telling them how clear they had to be and in what context. So in another climate case called Utility Air Regulatory Group, the Supreme Court, so we expect Congress to speak clearly if it means to address a question of great economic and political significance. And so there they started really to be, their eye was on Congress, not just the agency, but on Congress, telling Congress how clear it had to be. And in fact, at that time, I wrote an article that said this, I think, is a clear statement principle that the court actually has really no business sort of demanding. And so it sort of moved along until it finally, in West Virginia, they said, there's actually a major question doctrine, and we're here to tell you that today. But at the same time, there was a parallel track, and this is quite surprising and disquieting in my view. Parallel track where people started to say, we realize that the Supreme Court has only twice in its history struck down a federal statute based on the idea that Congress cannot delegate its legislative power to any other entity. 1935, as Cass Sunstein from Harvard likes to say, the non-delegation doctrine had one good year. It was 1935. But a few years ago, people started to really quite seriously, and most important, justices started to say, we ought to look again at that. And at this point, there are, I count 5 justices who have openly either written or joined opinions saying that they are prepared to vitalize this long moribund doctrine. And the Justice Gorsuch wrote an opinion a few years ago saying, yeah, we should revitalize it, or in my view, vitalize it, since it's never really been that vibrant. But and the idea would be that one of the measures he would look at, or one of the factors he'd look at, is, was this a really important question? Well, you can see once you make that move, you can see the major questions idea and the non-delegation idea just traveling in parallel. And Justice Gorsuch has been making that case in every case of this kind since then. And so there's a worry that one, the justices are drawing on a constitutional principle for their statutory interpretation. And there is a way in which that makes, in a way, it makes it sound more powerful. And so to me, it makes judges a little bit more potentially aggressive. They're not just defending a particular idea of a particular statute passed in a particular year, they're defending the Constitution. And for the original justices on the Supreme Court, they think they're defending exactly what was meant in 1789 by these structural provisions. So the stakes for them are really high, and they seem a little righteous, honestly, self-righteous in talking about the major questions idea. I think because they feel like they have the constitutional winds at their back. So that makes it really important that the justices have separately been talking about non-delegation. The other problem and worry is that at some point they may well decide, you know what, you can't just have a clear statement. You can't just clearly give power to an agency. That's not going to do. You actually can't give certain kinds of power to agencies anymore. And I think West Virginia is actually kind of ambiguous on this point. I think that, as I say, 5 justices have indicated an interest in revitalizing non-delegation. And so I do worry that the next shoe to drop will be that a statute at the federal level is invalidated because of this idea about non-delegation, and based crucially and quite remarkably on the justices' idea of what they regard as an important policy issue, which of course is just highly, highly subjective and malleable and unpredictable.
So this opinion really strikes at the role of each branch of government and the relationship between those 3 branches. So the separation of powers and the checks and balances, all of that comes into play with this, this case, and you've touched on it in your discussion. So I want to really probe that for the 2 of you. I guess starting with Lisa, because you're focused on the executive branch right now. How do you think this changes the relationship between the courts and the executive branch? And then I'll ask the same question of Greg as to the legislative branch.
Yeah, I think it can't help but be on agencies' minds when they're coming up with new ideas. And one of the, I think the unfortunate facts is that it applies in the areas that are the most important, right? And this is a decision that invalidated a creative approach to an important problem. And so there's a way in which at the moment when the agencies or the unelected bureaucrats, as people like to call them, when they are at their most consequential and resourceful and creative, that's when they need to worry. And so I worry the effect on the agencies, just the sort of chilling effect that may not even be conscious at the agencies. I remember when I was at EPA during the Obama administration, if you all don't know, there's a review process that takes place in the White House, and agencies can't issue major rules without passing that process of review. And I was told by more than one employee at EPA that they felt they didn't even think of new ideas that they thought OIRA, this office in the White House, wouldn't pass. It's like it totally shrunk their area of potential regulatory activity or creativity, because they knew at the end of the day they'd be judged on this quite narrow criterion. And I think of that when I think of the effect on agencies now, is I do worry that they'll pull back more. And now maybe you'd say, well, maybe that's a good thing. Maybe you're not hugely fans of regulation. But, you know, whatever the agency does in this domain, where they're issuing big rules, big regulations, they have to go through a process for it. And then they have to have it reviewed in court. And so that, sure, they may dream big, right? But, you know, at the end of the day, their stuff will be reviewed in court. So I do worry that they're not encouraged to dream big. We'll catch it if they make mistakes, but they can't dream big. And we have a lot of problems out there that we could be solving. The other maybe more subtle point is that I worry about when you think about the role, the effect on the relationship specifically between the agencies and the courts. I do worry about the Supreme Court's use of its so-called shadow docket here. The stay of the Clean Power Plan, with which Greg mentioned, is arguably one the first most consequential use of the shadow docket in the way the Supreme Court is regularly using it. Without full briefing and oral argument, it will issue a stay that really turns the tables in a major piece of litigation. And the reason I worry about that here is the major questions idea is really quick. You take a quick look at that, you say, whoa, that seems important, done. Stay the rule, and then it goes up to the Supreme Court, and the Supreme Court maybe just says, yeah, that was fine, you know, or maybe the district court says, no, you know, we've been asked to stay the rule because of the major questions idea, but we're not going to because we don't think it is. We'd like to hear more. Then they run to the Supreme Court immediately and ask for a stay. And I just feel like this gives courts that are inclined to be skeptical of agencies a quite easy test at a time when everybody's rushing. And the Supreme Court has shown itself really willing to reach way down into the district courts and alter their behavior.
Yes, I can absolutely see that. Greg, turning to you with your experience, you know, working for so long with Congress, how do you think this changes the relationship between the courts and Congress?
I think that I think the point on chilling agency action is well taken and well placed, because, you know, it is a long process, and surviving it, I can see agencies wanting to be very cautious there. You end up with this bizarre place where we have legislation that has a very generalized approach for addressing air pollution, so that it can address new threats as they emerge. And what we're ending up with is you can address air pollution issues that are of little consequence, but those of most consequence are not appropriate to address. And that seems pretty absurd. In the congressional context, I also think that there is an effort. I mean, there could be a chilling effect here. The Chief Justice, in his opinion, sort of cites as evidence that Congress never intended for the law to be used this way by referencing a comprehensive climate change bill that did not pass in 2010 by Congress, and essentially saying EPA has now implemented the same policy that Congress refused to adopt. And it was really, as someone who's very familiar with both the rule and that bill, it was a real analytic leap. The legislation from 2010, it was a 1,400-page bill that established a comprehensive climate change program. It applied to every sector of the economy, required dramatic emissions reductions through the year 2050. It had an auction mechanism that regulated entities would have to participate in to get credit allowances. It generated hundreds of millions of dollars a year in revenue. It invested that to transform the transportation sector, the agriculture sector. It invested in preventing tropical deforestation. It had deficit reduction money. It provided low-income tax breaks. I mean, the list just goes on and on. It was like the subject matter jurisdiction of like 9 different committees in Congress. And so I think citing that as somehow providing insight into a regulatory mechanism that has flexibility, but only applies to the electricity sector in very narrow and much less significant ways, just seem like a real, like quite the stretch to me. I mean, essentially, everyone is familiar with Justice Scalia's quote about how legislative history is like looking over the crowd and picking your friends. And for that reason, when the conference report in Congress gets together and they write out what they mean to do in a law, and it's the people who have written the law and they've worked on the law and they've had hearings, and we should ignore that, because that is going to be selective and biased. And that Scalia view has obviously become, I would say, dominant, at least at the Supreme Court level, but in many courts. And so we're now at the place where failure to pass an unrelated bill in 2010 provides insight into what Congress meant when they passed a law in 1970. And the Supreme Court knows that, and yet doesn't seem to be obvious to anyone else. And I don't think it's supported by the facts. I think requiring the level of precision and clarity that they're asking for is, as Lisa says, it's very demanding and I think unrealistic. Congress is, I think, responding in some ways. In the Inflation Reduction Act, there is a provision that provides $5 million to support state efforts to adopt California emission standards for zero emission vehicles and greenhouse gas standards for light duty vehicles. And I know that's kind of a mouthful, but essentially there's a program that allows states to opt into California's approach for vehicle regulation. And sure enough, it's being challenged now as a major question doctrine, as violating the major question doctrine. So in the Inflation Reduction Act, Congress provided specific funds. It's clear they've always been supportive of this authority. They've never repealed the authority. They've never constrained the authority. They've only expanded it over time. And now they're providing funding in a very concrete way to adopt those California standards. And I think that that has the opportunity of perhaps satisfying the major question doctrine. But it'll be interesting to see how the courts respond to that, because it's extremely difficult to get things done in Congress. And for that reason, Congress is very hesitant to revisit issues that appear settled in their eyes. And I know, as someone who worked in both the House and the Senate, incidentally, my Senate career ended 1 hour ago, so I'm now a free man again. But I would advise people, members of Congress would come and say, I really like what this EPA approach is, and I want to introduce a bill that tells them to do it. And the advice would always be, you don't want to do that. You don't want to create something directly on it that isn't likely not to pass. And here the court is sort of ratifying that. If we see efforts to address a problem and it doesn't make it all the way through Congress, we're going to hold it against you, Congress. And unfortunately, that's the vast majority of legislation. So how Congress adapts to this is going to be very challenging. And although we will see attempts to address major question doctrine, they're just not well suited for the kind of specificity that might be required to authorize some of these rules.
Well, looking at the case as sort of the lens through which we can examine the Supreme Court, what would you say about what this tells us about the Supreme Court makeup right now? And I'll start with, I guess, Lisa.
Well, I think the Supreme Court is one really, is the term feeling its oats. We're feeling our oats. Like there is something there in quite an aggressive mood, I would say. A number of them have long been sort of devotees of so-called originalist theory of the separation of powers. And they see their moment right now. And it feels like they have the votes, and they're in a hurry. That's the way it feels to me. And I can't emphasize enough how much a difference one more justice makes in the majority, that the 6 justice majority makes a huge difference. It's not just one more. It's like it's synergistic or something like that. It multiplies rather than just adds one member, because then one person can be dissatisfied and they don't lose a majority. And so I do worry that the new 6 justice majority and the mood they seem to be in, which is, as I say, pretty much in a hurry, doesn't bode well. I worry, honestly, I will say, I worry about the stories that just keep multiplying about conflicts of interest on the Supreme Court. Ideological conflicts of interest insofar as it involves activism in support of insurrection. I also worry about the financial conflicts of interest that we don't know anything about, the failures to disclose spousal income from sources that have business before the Supreme Court. I worry a great deal about that. And there is a way in which, and I hope that I'm not just sort of being paranoid, but there's a way in which these sort of all come together in these regulatory cases. A lot of money's at stake. There's a lot of money to burn on the other side in getting justices on the court, getting them passed through the Congress, right? We saw tens of millions of dollars apparently was shepherded by Leonard Leo at the Federalist Society in support of the 3 recent justices appointed. And a lot of those, the financial ties actually are connected with the kinds of groups that are supporting the litigation in front of the Supreme Court, the regulatory litigation. And so I worry about just their ideology and judicial philosophy, and about much more sort of surprising, in a way, matters, but I think quite dramatic ones, such as the conflicts of interest and the fact that we just don't know much about their own potential conflicts.
Great.
Yeah, I would a lot of that resonates with me. I think that here we have I went back to take a look at Justice Barrett's confirmation hearing, in which she talked about how she didn't want to comment on climate change because it was politically controversial. And then I put that with the political and economic significance of this, and it makes me worry about it. I feel like it's been underappreciated just how much of an issue climate change has been for judicial appointments, for elections, and every once in a while you get a peek at it. But I also worry about that, about neutral application of the law versus outcome specific results that the justices are after. And I think we got a good taste of that with the Dobbs decision as well. I saw that a poll came out just yesterday from Gallup that said public trust in the Supreme Court is now at a historic low. It's down 20 points in 2 years. And so we're now at a point where we're just 47% of Americans say they have a great deal or a fair amount of trust in the Supreme Court, the lowest level since 1972. And like so many of our public institutions or public issues, the split is falling along partisan lines, which I think is also troubling, that we're seeing that divide as well. So none of us, I think, as lawyers really want the Supreme Court to be making decisions based upon public popularity, but I think that it's being perceived that they are making decisions for ideological reasons. And that's, I think, also reflected in the polling. And there's, we've now reached a point where an issue of court expansion, which was something I don't think that was in the popular mind a couple years ago, now claims support by more than half of the Americans. again, with a bit of a partisan split there. I think 75% of Democrats support it, and maybe half of that or something of Republicans. So I think, we have a lot of challenges in the court right now, and and maybe that explains some of this explains why they're in a hurry. I don't know, but I do. It does just makes me worried about the ability of our institutions to tackle these challenges, and the rule of law, frankly, in our society.
Well, we have about 4 minutes. I'll just leave you with an open-ended question. Maybe you can answer it in just a sentence or two, each one of you. What should we be watching for as we move forward as a result of this decision? Lisa, start with you.
I think we should be watching for just the proliferation of challenges based on major questions. They're happening all over the country. So I do, that may seem like an obvious point, but I think it's a really important one, because a lot of times lawsuits get filed, they sort of go to ground for a while, they're quiet, and then suddenly pop up and there you are. And I think that's right now we're seeing a lot of lawsuits. They're filed against rules. A lot of people saying that rules that haven't been published yet are dead on arrival because of this doctrine. And so I think we want to keep an eye on it, like really keep an eye on it, and see what happens. The court promised that this was reserved for extraordinary cases, but we've already seen, at least in the lower courts, that doesn't appear to be true, certainly for the litigants. So I guess I just have that simple desire that we keep an eye on it, even when the cases seem to be quiet for a while.
Okay, Greg.
I really would just associate myself with those comments. I think we're going to see, I think major questions doctrine is going to become a major area of litigation in the next few years. And we're already seeing conservative judges at every level invoking it. So I think it's going to be a big deal.
Well, neither one of you has a crystal ball, but we do have two minutes. We don't really have time for questions, I'm afraid, from the audience, but here's a wild card question. If you thought there was a juncture at which the court's power over the court's use of the major questions doctrine could go either way, what would you say that juncture would be? Lisa? What is the next big test, do you think?
I'm going to say something maybe that you don't expect, and it could be wrong, but I do think the court is going to face a real moment if somebody comes to the court saying that the agency's refusal to act answered a major question.
Interesting.
Agency gets a petition like it did in Massachusetts versus EPA. The agency denies it, and they say, look, we're not going to regulate greenhouse gases because it's too big a deal, denied. That should be an answer to a major question. To me, actually, and I didn't get into this, and now I won't really, but whether they say no or yes, it's the same question in every case. And so at some point, the Supreme Court is going to have to explain why its cases apparently suggest that only regulation and not lack of regulation or weak regulation violates the major questions doctrine.
Well, I'm really glad I asked that question. Greg, do you have anything to add in about 20 seconds?
There's I guess we will see the DC Circuit address federal authority to set greenhouse gas standards for light duty vehicles in early next year. And I think that'll probably tee up the question as well. I wouldn't, that's going to be so important to the oil industry. And my guess is that could become an issue the Supreme Court gets interested in.
Yes, certainly. Well, we are unfortunately right out of time. We just finished this panel. I want to thank you both so much. You've given us so much to think about on so many different levels, really. It's been a privilege. And I want to thank the audience for joining us for this terrific panel. And we hope you all have a terrific rest of your day. Thank you all so much.
Thanks, Professor Wood.
Thank you so much.
That was fantastic. We are doing a quick change for our next panel. So we do have a break after this next round, but stay, you can stretch. But I'm gonna shut this down, and then we're gonna invite Judge Acosta up to come up and introduce our next session.